ಡಿಫಾಲ್ಟ್ ಆಗಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅದಿರಾಗ್ಬಿಟ್ಟೈತೆ. ನನ್ನ
ಸರ್ ಲೈವ್ ಸರ್ ಡೇಟ್ ಅದು ಕೊಡ್ತೀನಿ ಸರ್.
ಏನು ಅವ್ರು ಸುಬ್ರಹ ಮೇಡಮ್ ಫೋನ್ ಮಾಡಲ್ಲ.
ನೋಡಿ ಸರ್.
Shall we start, ma'am?
Yes, of course.
Sukrita, ma'am, shall we start?
Yes, Padma.
Yes, you can start, ma.
Okay, ma'am. Good evening, everyone. I, Padma BS, librarian, take the privilege of welcoming you all to the second session of 5 days FTP on intellectual property rights organized by our college from 15th April 2025 to 19th April 2025. I feel happy to welcome our beloved principal, Professor Bharti N, to this program. I also welcome Srimati K. Sukrita, Head Department of Computer Science and IQAC Coordinator to this session. Previous day, we had a wonderful session on the topic overview of IPR by Dr. Ullas P. And today we have with us Ms. Sai Priya Balasubramanian, registered Indian patent and trademark agent, independent practitioner from Bangalore. Today she is going to lecture on the topic National and International Framework of Patent. I am delighted to introduce today's speaker, Ms. Sai Priya Subramanian, to you all. She got her Masters in Bioinformatics and pursuing her LLB from Karnataka State Law University. She has worked in various companies at different capacities. To mention few, she worked as a patent associate at Singh and Associates, as senior research associate at Steer Life, as a patent attorney heading life sciences at S&H Partners, as senior patent attorney at Zacco. She has also got the experience as senior business intelligence and IP analyst at Rapid Alpha Inc. for EO. At present, she is a freelancer, startup advisor, performs patent drafting, trademark filing, and helps startups with patent searching, trademark searches and filing, and other related works. She is committed, responsible, dynamic, and strategic IP professional with a decade of experience across patent law, intellectual property management, and technology. On behalf of MMK and SDM Mahila Mahavidyalaya, I welcome you, ma'am, to deliver the lecture.
Thank you.
What to you, ma'am?
Thank you, ma'am. Thank you, Mrs. Padma, ma'am, as well as the principal and Sukrita, ma'am, for inviting me over. So, shall I start the session?
Yes, you can, madam. You
Yeah.
can start.
Is it visible?
Yes, ma'am, it is visible.
Can you see the first slide, ma'am?
No, you are not, I think you have not yet shared your slides.
All right, just a second. Is it visible now?
Yes, it is visible.
Yes, ma'am. Yes.
Yeah. First slide is visible, ma'am.
Yes, ma'am. Give slideshow, ma'am.
Yeah. I think I've given slideshow. Is it all right? I've given slideshow. I think it is all right. Let me know if it is not all right. If the slides are not moving. Is it moving?
No, ma'am.
No, ma'am.
No, it is
No,
not
yeah, now
moving.
it's moving.
Now, yes.
Slideshow
Now
it
it's
is.
moving.
It's visible, right?
Yeah.
All right. So, yes, the topic which I'm going to discuss and share with you all is national and international framework of patent filing. So, before I begin to explain more on this topic, let it be an interactive session. I have, brought up a scenario where an inventor is trying to has come up with a novel molecule which helps in inhibiting an enzyme which is involved in a rare metabolic disorder. So let her name Dr. Ananya. So Dr. Ananya works in a small lab in Mysore, say. So she wants to protect her invention. She knows it is going to be a life-changing invention for many of the patients suffering from that particular metabolic disorder. So she decides to protect the invention both nationally and internationally. So first, nationally, what she tries to explore is that how it can be protected. So she gets to know that Indian Patent Office is the apex office where patents are being filed. So she decides to draft a provisional application. So what do you mean by a provisional application? Provisional application is a small draft of idea of your invention. So it is not a complete invention. So you will get to know what is a complete invention as we progress through the presentation. So after she files the provisional application, she gets to know that she has 12 months of time in filing her complete invention. So she also gets to know that she needs to, file a request for examination in order for the patent office to examine her invention. And after examination, the grant of her patent is subject to opposition, such as a pre-grant opposition, where any interested party can object to the grant of her patent due to various reasons. So even after the grant, the enforcement of her patent is affected by post-grant opposition. So she also gets to know that after the grant of her patent, she has to renew her patent in order to make the patent valid. I think we all know that the patent is valid for 20 years, after which it falls into the public domain. So now Ananya has a clear national framework of how the patent has to be filed in India. So next, she also, understands that her invention has got potential in countries like Germany. For example, a researcher from Germany, knowing that she is working on a particular molecule, approaches her to give certain data. So, Ananya thinks that it is important for her to protect the invention in Germany as well. And a company, a pharmaceutical company from US is behind Dr. Ananya to know more about her invention so that they can commercialize a product involving that particular molecule. So Ananya gets even more interested to know how to file her invention in US. So she gets to know about the international framework also. She gets to know that there are two modes through international mode through which she can enforce her patent in different other jurisdiction. One is the Paris Convention, the other one is the PCT route. With Paris Convention, Ananya has only 12 months to enter into jurisdiction of her choice, whereas through PCT mode, she has 31 months of time to enter into her jurisdiction of her choice. So with all this information in hand, Ananya protects her, chooses PCT route and enforces her patent in countries like Germany, US, and Japan. So why do we think all this information is important? Because so having all this information in hand, as a researcher, what you can do is that you can first of all take informed decision. Second would be you can plan your course accordingly, and you can also license out your invention for the companies which are located internationally. And the fourth advantage would be you can attract various kind of investors by building your own startup or spin-outs of your choice. So with this brief introduction, I would like to start today's presentation. So let me move to my next slide. So how this topic is pertinent to universities. So because the way the university operates these days is quite different from the role of a university probably a decade ago. So in the past, universities were mainly involved in imparting education, and they were also involved in generating a new kind of knowledge through research. Apart from that, they were also involved in the transfer of knowledge generated to the public for the society to grow. So, but what are the role of university of this generation, of these years? So they are not only involved in the transfer of knowledge, they are also involved in the management of the research funds, which has been granted by the government. And they also draft various research contracts with third parties and governments as well. And between the researchers who is involved in a particular research in the university lab. So apart from that, university also does evaluation of technology and the protection of risks which comes out of these research. So they also license out with a third party or a company in order to take out the invention to the market. So it all leads to increase in collaboration of the university with the industry. So apart from these things, we can see industry is the birthplace of lot of startups and spin-offs. So a lot of biotech startups and research startups find their birthplace in a university. So university also does IP training as we do today for the researchers. So and also the administration and implementation of IP policy. So since the role of university is increasing multifold, it is important to understand and protect the research you do at university level and protect it globally so that you can reap the best return on investment. So I'll move to the next slide. So what do you mean by intellectual property? Anything that is a creation of your brain is called intellectual property. So a property can generally be a tangible property. Tangible property is something you can touch and feel, and a property can also be an intangible property. Tangible property as in a car you own, a house, the amount of investment you have in your bank, or all comes under immovable property. Intellectual property can be divided into two types. One is the industrial property related, IP. The other one is the copyright related. So all these patents, trademarks, designs, geographical indications comes under industrial property related IP. So this is a brief outline of the Indian Patent Office, how it works. So patent office is located in different jurisdictions, say Delhi, Chennai, Mumbai, and Kolkata, basically for different direction, north, south, east, and west. And we also have design office, which is based in Kolkata. We have our trademark registry as in Mumbai, Delhi, Kolkata, Chennai, and Allahabad. and we have a GI registry operating at Chennai. So since we are concentrating only with patents today, I will delve more into the functioning of patent office. So, moving deep into patent and patent filing procedure, I will give you a brief introduction on what is a patent and what is granted as a patent, the term of the patent, and all these, basic structure of a patent. So, generally, patents are granted for a product. A product, what can be a product? A novel antibiotic compound, a novel molecule can be a product. What can be a process? For example, a fermentation process, a new fermentation process can be a subject matter of a patent. So, a patent has a valid term of 20 years right from the date of filing. And when you file an application, you should also request for examination. So as I said earlier, grant of patent is subject to pre-grant and post-grant opposition. When it is opposed, what you will do? You will either go to patent office for appealing for its decision. You will also go to there is a board called IPAB, which has been abolished now. So you have jurisdictional high courts where you can approach against the decision of the patent office. So since we are dealing with audience from life sciences background, I would also like to stress that there are specific provisions which exist in Indian patent law, which helps in safeguarding biodiversity and traditional knowledge. So every patent application you file is published after 18 months of filing date. You also have an option of early publication of your patent application. So in order to reduce the timelines of grant of patent, you also have expedited examination and early publication options, so that your patent is granted on a fast track basis. So with this idea about patents, let me start with the what is what underscores the patent enforcement in India is Indian Patents Act 90, which was enacted in the year 1970. So it has definitions for various terminologies used in filing a patent. For example, when we talk about patent, it is always about an invention. So invention, the term invention is defined. And I would also want to let you know that Indian Patents Act has 162 sections. There is also a set of rules accompanying Patents Act. So there are, I think there are 138 rules with regards to Indian Patents Act 2000, which was enacted in the year 2003. So Indian Patents Act 1970 defines invention under section 21J. So what do you mean by invention? Invention means a new product or a process. It has to have an inventive step, and it has to have an industrial application. So the word invention talks about three important criteria. The first one would be the invention has to be novel or it has to be new. And the invention can be a product or a process which has a novel inventive step. Novelty, and it has inventive step. And the third criteria is it has to be industrially applicable. So these are the three golden criteria for your invention to be patentable. So can I move on to the next slide if everything seems clear?
Yes, ma'am.
All right. So as I said earlier, what is a patentable subject matter? Can anything and everything can be patentable? No, it is not right. So what is patentable? Any new process or a product or both can be patentable. So as we discussed earlier, it has to be novel, it has to have an inventive step, and it has to be industrially applicable. So, I mean, what cannot be patentable has been clearly mentioned under Section 3 and Section 4 of Indian Patents Act 1970. Let's look into detail what are not patentable, what Indian Patents Act talks about inventions which are not patentable. So apart from these three golden rule and invention, as against the concept followed in universities, generally if we work on a research, we publish in a leading journal. But if you want to, file for a patent application, you should make sure that the particular information which you're planning to file for a patent should not be published in India or anywhere else. So it should not be in prior public knowledge or prior public use within India. And it should not be a part of any patent application in India. So a feature of invention is that there has to be, it has to be technically advanced as compared to the existing knowledge. Existing knowledge includes both the information on that particular topic of research published in any research journals or any patent application. And it has to have an economic significance. And also, the invention should not be obvious to the person skilled in the art. Person skilled in the art, in the sense, a person who is practicing in that particular research field, as he goes through the invention, he should not feel that the invention is quite obvious. Any person who has basic understanding of that particular field can, they should not be able to practice the invention without the information, without knowing the information present in the patent application. So the third criteria, as I said earlier, is industrial application is very important. If there is no industrial application, then the patent application is liable to be rejected. So, so far we've been talking about invention, patent application, and all these concepts. So you should also know the parts of a patent application. So, I mean, you can file an application, patent application, when you are pretty sure that your invention solves a problem. And if you know that there is an improvement to the existing process or a product, then you can very well go and file for an application. And if you feel that a particular composition or your invention, be it a machine or a diagnostic kit, has increased efficiency over the existing products or process. So if you know that all these factors exist in your invention, so you are good enough to go ahead and file for a patent application. So the invention has to it has to exhibit an improvement over somebody else's product, even if their product is already patented. And there is a misnomer and misconception that for filing a patent invention, the invention has to be complex. So it is a very wrong view. Among the researchers who are intending to file an application, it is not that your invention should be complex all the time. It can be as simple as it can be, provided it has to contribute technically. There has to be some kind of technical advancement. If it is there, then you can very well go ahead and file for a patent. So what does a patent application look like? So it has to have a title, and it has to have a specification part and claim part. It also need to have an abstract. The title of the invention, generally it should not exceed 15 words, and the specification has different parts. Namely, first of all, it has to denote the field of invention to which it belongs, followed by brief background. So in the background, what do you talk about? You generally talk about the existing patents or the publication you have come across so far, which relates to the invention for which you are filing a patent. So there you need to talk about the problems of the existing art. And then maybe you can followed by a few objectives of how you're going to solve the existing problems, followed by a brief summary of your invention. So then follows the detailed description. Detailed description should contain various examples of experimentation being conducted and the results you had obtained, proving the technical advancement as against the existing art. So it also has to contain figures, which is explaining your invention. And coming to the most important aspect of a patent application is the claims part. Claims part gives you the legal right and the boundary, boundary against which your infringers cannot trespass. So if they cross the boundary, you have all the right to claim legal damages. So this is the right. So a patent right is also called as a negative right, since it gives you the legal right to stop anybody from using your invention. So yes, so it's important for researchers to know more about what is not patentable under Indian Patents Act. As I told earlier, Section 3 and 4 of Indian Patents Act 1970 talks about what is not patentable. So Section 3A, it talks about frivolous invention. Frivolous inventions or inventions which are contrary to natural laws. For example, if you come up with a clock which has 48 hours as against the 24 hours we have per day, then it is against the natural law, right? So you cannot claim a patent for that. And if another example would be you're filing a patent for a machine which tells that it gives you greater than 100% efficiency, then it is against the natural law, law of conservation of energy. So again, for these inventions, a patent application cannot be filed. So Section 3B, what it talks about, it talks about the invention whose use is contrary to public order or morality. So if somebody is coming up with a device that performs gambling, then Indian government will not grant a patent for that because it is against the morality and public order. And also another classic example would be a house-breaking tool. And genetically modified crops which affects public's health is also against public morality, and due to ethical reasons, Section B prevents a patent being granted for such invention. So Section 3C, it talks about, mere discovery of a scientific principle or an abstract theory or discovery of any living or non-living things occurring in nature cannot be patented. Einstein's theory of relativity, Newton laws, these are all classic scientific theories. But do you think a patent was granted for all these laws? No. Why? For the reason that they are just mere discovery of scientific principles which are existing in nature. So hence they are prohibited from being patented. So I mean, whenever somebody comes up with a scientific principle, or if they have come up with discovering a novel living organism, so you should be sure enough that a patent cannot be granted for such discoveries. So Section 3D, Section 3D is very, very important and special to Indian jurisdiction, as we have rejected lot of patents because of non-compliance with Section 3. So what does it talk about? So, so for example, you have a known drug. So, for example, and you have come up with a new form, isomeric form, for example, a crystalline form of a specific of a drug molecule for which has been patented already. So you think that, I mean, it's a new isomeric form, so I can go ahead and file a patent. So it will be outrightly rejected on the basis of Section 3D because of the reason that it is just a new form of a known substance. Even if you come up with a new use of a known substance, it cannot be patented under Section 3D of Indian Patents Act. So, but provided if it has efficacy, hello. So if it has enhanced efficacy, then that particular composition or that particular form of the known drug can be patented. So section I have included another example as well. I mean, for example, if you have identified new use of aspirin, you cannot file a patent for that because aspirin is already a patented compound, so it cannot be patented. Section 3E talks about admixture of various substances without any synergistic effect. So, for example, to molecule A and molecule B, a combination of molecule and for molecule A patent already exists. For molecule B, another patent already exists. So now you are working on researching the combined effects of molecule A and B. So what do you do in your lab? You just combine molecules A and B and come up with a new, you think that it's a new composition. So hence you apply for a patent. So for that patent, if you are able to demonstrate a synergistic effect, what do you mean by synergistic effect? So A plus B should not be just the combined effect of A plus B. So there has to be a surprising effect because of that combination. So it should not be functioning, molecule A should not be functioning separately, molecule B should not be functioning separately. When you combine together, there is a combined effect of both A and B, which is not achievable when they are used individually. That can be called as a synergistic effect. A combi flam is an example of that, and a soft drink mixture is also an example of Section 3E. So Section 3F, what does it talk about? It talks about mere arrangement or rearrangement of known devices working independently. For example, you carry an umbrella during a rainy day, and you have a fan also. So during during summer, you are, you would want to come up with a new device which is an umbrella that is fitted with a fan. So, and you want to, you're thinking, why don't I get this concept patented? So patent office will say a big no, because so umbrella is a separate device, fan is a separate device. So when you combine these two, I mean, what is the novelty in that? There is no novelty in that. So hence, as per Section 3, such a combined component, combined project will be rejected outrightly. Section 3F, it talks about any new method of agriculture or horticulture, or any method of novel method of plant cultivation cannot be patented. And Section 3I, this is also a classic section when it comes to life sciences patents. So mainly talks about medical, surgical, therapeutic, and diagnostic treatment of humans or animals are not patentable. For example, if you consider a novel method of vaccination and a novel method of blood transfusion, which is either a method of diagnosis or method of treatment, which is not patentable as per Section 3I. And Section 3J talks about plants and animals or seeds or any part of plants as a whole or in parts cannot be patented. Animal clones, plant varieties, all these things cannot be patented. And Section 3A talks about mathematical methods, or business methods, algorithms, and computer programs per se cannot be patented. These days,
Hello, Chaitra, please unmute yourself. Chaitra K. Hello, Chaitra K. Please unmute yourself. Chaitra, please mute yourself.
ನಾನು ಚೈತ್ರನ್ ಕರ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದೀನಿ.
Chaitra, mute yourself.
ಕಾಂಪ್ಲೆಕ್ಸ್ ಮಗುನು ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ನಾನು ಫೋನ್ ಮಾಡಿದ್ರೆ ನಾಳೆ ಮಗುನ ಕರ್ಕೊಂಡು ಬರ್ತಾರೆ.
so can you continue?
Hello.
ಹೌದು.
Ma'am, your slide is not in presentation mode.
All right. Is it fine? Is it fine now?
No, ma'am. Press F5 button.
Because I am able to see the presentation. F5. Okay.
Yeah, you can see, but it is not in presentation mode. Fonts are looking very, it's very small fonts.
Ma'am, you can put on the slideshow mode.
Is it fine?
Click on slideshow.
Yeah, I did that. Or should I reshare?
Yeah, I think it's better.
It's better? Okay.
Yeah.
Okay, can I continue?
Yes, ma'am.
Yeah. Section 3, as we are in the era of AI, I mean, I also have a lot of clients coming up with digital healthcare apps patents. So they always ask me, they say computer program per se is not patentable. Ours is a computer program based app. Do you think it is patentable? I always tell them it is patentable because if it is connected to a hardware and if there is a technical contribution achieved by that particular program, then that is very much patentable. It all falls under Section 3K, where it talks about any mathematical or business method or algorithms or computer program per se is not patentable. Section 3L talks about any literary, musical, artistic works, TV as well as cinema creations are not patentable. So a movie or a song or any book will not come under the ambit of Patents Act as it falls into the copyright domain. It can be copyrighted, but it cannot be patented as such. Section 3M talks about any kind of mental act, games, rules or schemes cannot be patented. Therefore, any kind of business model or any mathematical method, as we have seen earlier, or any puzzle solving method cannot be patented. Section 3N prevents patents for mere presentation of information. For example, flow charts or any graphical or visual way of displaying information cannot be patented. And 3O talks about topography of integrated circuits, though it is not very much related to life sciences patent. It can affect, software related, hardware and networking side researchers who are intending to file patents under that particular field. And Section 3P is also an important section when it comes to researchers. So, which talks about composition using traditional knowledge of known components. For example, we all know that haldi can be used for wound healing, so as neem. So a composition using these traditionally known components is barred from patenting as per section 3P. And section 4 relates to all the invention related to atomic energy, which falls under Atomic Energy Act 1962. For example, any invention using uranium or thorium or lithium, etc., cannot be patented. So there is a quiz coming up, which is based on all these sections. So I think, I mean, you will find it interesting as we approach that section. So with this information in hand about what can be patented and what cannot be patented, let's look into the stages of patent filing. So this is the general flow chart, how a patent office deals with the patent application. You file with them. So you file either a complete or a provisional application, patent application. So if it is going to be a provisional application, you will get 12 months of time for filing your complete application. If you are not going to file your complete application, then your application is liable to be abandoned. So once you complete your file your complete specification, so after 18 months, your patent application is being published in the Indian Patent Office website. So you also have an option of early publication as well. So after publication, no, even by filing the application, you can request for examination. So you can request for examination for within 31 months. So it has been 48 months earlier, but in 2024 there was an amendment which reduced the timeline for filing request for examination. So as per the current rules, you can file the request for examination within 31 months from the date of filing of your patent application. So once the patent application has been filed, it can be opposed by any person or any organization under a pre-grant opposition. So the difference between a pre-grant opposition and a post-grant opposition is after once your patent application is published, you can any interested person can file a pre-grant opposition. So once it is granted, any person can file a any person means it can be an organization or an individual as well. So post-grant opposition means once the patent has been granted within 1 year time, any person can file for a post-grant opposition. After the patent application has been examined, either it will be granted or it will be rejected as per a patents office discretion. So after this examination process, there will be a report called first examination report, which is issued by the Indian Patent Office, for which there will be a set of objection the controller would have invoked, for which you need to file a reply. So if the examiner is convinced on your reply, he can either go for the grant or he can reject the patent. But before rejecting, they will give you an opportunity to be heard. So after that process, the disposal of that patent application happens. So after that, once the patent has been granted, it is very important for you to renew the patent from 3rd year onwards, right up till the 20th year of the patent. So we just saw the overview of how the patent application will be dealt by the patent office. So I will explain each and every step in little more detail in the upcoming slides. So how will you obtain a patent? So first of all, you file an application for patent. So it will, for example, in our case, Dr. Ananya was working in a lab in Mysore. Mysore falls under Chennai jurisdiction. So Ananya will have to file an application with Chennai Patent Office. So as per the place of office or residence of the applicant or the agent, a patent application will be filed. So there is a fee associated with every patent application. So you have to pay the fees for your application to be considered. Apart from the patent application, there are different forms, such as your application will fall under Form 2. And there will be a Form 1 where the invention will be assigned to a particular company or a research laboratory or the university for which you are working. And there will be Form 3 for inventorship, and there will Form 3 will be statement of undertaking as to where you have, as to which other jurisdiction you have filed your patent. For example, if you have filed a patent in the US, or if you have filed a patent in Europe, you need to give the same information under Form 3. And Form 5 is the declaration of inventorship, where you need to mention every inventor who is contributing to the invention, the address and other related information of the inventor. So yes, and if you are filing a request for examination, there is a fee associated with that request also. That comes under Form 18. So there are different forms which is used for different purposes. And it is good to have a basic understanding of these, forms which are required while filing a patent application. So all this information which I'm talking about regarding the different forms and the different fees required to be paid is clearly mentioned in IP India website. So if you have a chance after this presentation, just go through this website so that you can have a fair understanding of how Patent Office operates. And there is also a different guidelines and manual for applicants to go through. You can also go through the same resources to understand better, especially if you're having an intention of filing the patent application for your prospective research or your current research. So as I said earlier, when you file a patent application, it is published after 18 months. So in 19th month, the application will be published in the Patent Office Journal. So it is an online journal which is available with IP India. You can also have a look at it. So there is also an option for an applicant to get his application published before 18 months under early publication option. So you can also explore that option if you are looking to fast track your grant. So in that, if you opt for early publication, it will be published within 1 month of the request. So request for examination. So a patent application will not be examined unless a request is made in the requested form and the requisite fee has been paid along with your application. So previously, till last year, you were having 48 months time for filing a request for examination, which has been reduced to 31 months currently as per Patent Amendment Rules 2024. So what happens during examination? Your application is sent to the examiner, and within 1 month within 1 month from the date on which the request for examination has been raised. So what does an examiner do during examination? So he examines whether the claimed invention is not prohibited for grant of patent. So he also sees whether the criteria of patentability is complied or not. So basically, the criteria for patentability as well as whether it falls under non-patentable invention or not has been thoroughly scrutinized by the examiner. Then he issues a report called first examination report for the applicant to go through the objection which the Patent Office has, and you will be given a chance to comply with the objection raised by the examiner. So 1 month time is available to the controller to vet the examiner's report. So after he gives a go-ahead report, the applicant will be notified about the issue of first examination report, and the applicant will have only 6 months of time to comply with the report. In case if you are missing to reply the report, the application will be abandoned, and all the money you had spent for filing the application will be of no use. So it is very important to take this first examination report seriously and reply to this report. So, response from the applicant has to be made within 6 months from the date of issue of first examination report. So, if the objections are not met, grant of if the objections, in case if you are meeting with all the objection raised, then your patent will be granted after within 1 month from the period of such compliance is made. So as I said earlier, pre-grant opposition can be filed by any person. Even you can, a researcher, who feels that his research has been copied by somebody else and he has filed an application without his knowledge, and after that if he comes to know that a patent has been filed, to which he has also contributed, so he can oppose for the grant of such patent. Before it is being granted, so that under pre-grant opposition. So who can file? Any person. It can be an individual or an organization or even a competitor. So what is the timeline within which you can file a pre-grant opposition? After the patent application has been published, but before the grant of patent, you need to file for this opposition. So how can you file? You can file a representation to the controller, explaining clearly why do you feel that particular patent should not be granted. So along with that, you need to provide the evidence also as to why you do not want the patent to be granted. So you will also be given an opportunity to be heard before any decision is made, whether to reject the patent or to go ahead with the grant of the patent. So you might be wondering what can be the grounds on which a pre-grant opposition can be made. So as I said earlier, it can be a wrongful obtainment of the invention. So if you feel that the invention has lacks novelty or inventive step or industrial applicability, you can go ahead and file for a pre-grant opposition. If you feel that particular invention falls under non-patentable subject matter, in that case also you can go ahead and file a pre-grant opposition. And if you feel that the inventor has not disclosed the best method of performing the invention in his application, he has not revealed certain important data which you think is very important for the grant of a patent, then there is an insufficient disclosure, right? So even in that case, you can file a pre-grant opposition. Even if you come to know that that particular invention has been published anywhere else, or if you feel that it already lies in the public domain, or it has been published in a different journal, you can use that as an evidence and prevent the grant of such patent. So non-disclosure of any crucial information can also be a subject matter on which a patent should not be granted. So that can also be a ground for a pre-grant opposition. What you have to consider before filing a pre-grant opposition is that when you consider a pre-grant opposition, you need to send your application as well as the relevant evidence, a copy of all those documents to the applicant as well. A period of 3 months is allowed for the receipt of the response from the applicant. If it is not received, if a response is not received from the applicant, then the application will be abandoned for sure. So after examining the opposition, the submission made during the hearing, the controller may either reject the opposition or grant the patent, or accept the opposition, or he can accept the opposition or ask the applicant to modify or modify the patent accordingly, or he can also outrightly reject the patent application based on the allegation which you have mentioned in your opposition. But all these things have to be done within a period of 1 month from the date of completion of opposition proceedings. So grant and renewal, as I said earlier in the flow chart, after a patent has been granted, it is very important for the holder of the patent to renew it periodically. The period of a patent is 20 years. So from third year onwards, you need to pay a renewal fee to the patent office. So once a patent has been granted, a letter of patent will be issued within 7 days. So the grant of such a patent will also be published in the official journal. So the fee which has been accrued after the grant of patent has to be paid within 3 months. You will also get an extension of 6 months as per section 142 subsection 4. No fee is requested from the applicant for the first and second year. So renewal fee has to be paid on yearly basis, right from the third year to the 20th year, for keeping the patent alive or keeping it in force. If you fail to pay your renewal fee even after the limitation period, that patent will be revoked. So delay up to 6 months from due date is permissible, but beyond that it is not permissible. But even if you're delaying for 6 months, you need to pay a fee for the extension of time. So what happens if you don't pay the renewal fee? It's very simple, your patent lapses if it is not paid within the prescribed time period. So now you have a fair idea of national framework of filing a patent and how to take it forward until grant. So and also keeping it in force for the term of the patent. So now and then in our case, in the classic example with which I had started this session, Dr. Ananya was interested in implementing her invention across different geographies. Say she wanted to implement her invention in Germany as well as in the US. So for which she was getting to understand how to enforce her patent internationally. So we will see what are the options available in order to enforce your patent internationally. So there is this organization called World Intellectual Property Organization, called as WIPO. They have administered several treaties for enforcing patent in different geographies. So some of the important treaties are the Paris Convention. It is a convention route which was Paris Convention happened in 1883, and the very famous mode of filing patent application internationally is Patent Cooperation Treaty. That is the Strasbourg Agreement, which was enacted in 1971, and Budapest Treaty, which happened in 1977. There is a patent law treaty which was recently enacted in 2000. There are certain treaties which falls outside the ambit of WIPO, like World Trade Organization also enacted this agreement called Trade-Related Aspects of Intellectual Property Rights. This TRIPS agreement happened in 1994. India is also a compliant of TRIPS agreement, and there are also several regional treaties like EU IPO is European Union Intellectual Property Organization. Africa also has ARIPO. Different regions has enacted several treaties for their intellectual property enforcement. So among all these, PCT is the classic route. So I will explain in detail about PCT as well. So this Paris Convention is the first international convention for filing patent internationally. So it covers not only patents, it also covers other forms of IP, right? Trademarks, service marks, trade names, industrial rights, utility models, geographical indication, appellation of origin, and it is the place for repression of unfair competition. So what it sets out, so it has several features like national treatment. National treatment means if I am a party to Paris Convention, what applies to the citizens of my country will apply to will be the same for a member country who is trying to enforce his or her patent in my country. So that is called national treatment. Paris Convention gives you a time frame of 12 months so before which you have to enter the jurisdiction of your choice. So it also gives you territoriality in the sense, for example, if your patent has been rejected in China, it doesn't mean that the decision will influence is granted in the US. So US patent office will act independently, whereas a decision taken by the Chinese patent office will be independent of each other's decision. So it also gives the right to mention the inventor's name to be mentioned as such in the patent application. And also patent is not declared invalid because of the restriction on sale or use of invention under national law. For example, in order to understand this better, I will give you an example. For example, you have opted for a powerful pesticide compound in India, but later on, Indian government bans the use of particular pesticide due to the environmental law in force. So it doesn't mean that your patent is invalid. Your patent is still valid. This is an important feature of Paris Convention. And also compulsory licenses. So compulsory license, if your patent is not worked by the owner of your patent for valid reasons, the government grant license for a third party to work the patent. So this is called compulsory licensing, but a compulsory license is not always granted easily. So, for example, in India, we have granted a compulsory license to Natco Pharma for this Bayer's drug Nexavar for three important reasons. As it was too expensive for the patients to afford, and Bayer wasn't having a manufacturing unit to manufacture this drug Nexavar in India. And there were an increasing demand among the public, which was not met by Bayer. So hence a compulsory license was granted to Natco Pharma in order to manufacture in the required amount in order to cater the Indian patients. So this patent law treaty is not much known and not used much by the international applicants. But anyways, it's good to have a general idea about this patent law treaty. It was enacted on April 28, 2025. There must be more than 19 contracting states right now. So what it does, it streamlines and simplifies the formal requirements for national and regional patent application and patents, and there is also several ease of mechanism for changing your address, changing an applicant, owner, or filing your power of attorney and all those things. This might sound too legal for researchers, so hence I'm skipping this information and moving on to the next slide. So this is very important for you to know the PCT procedure, because it is the most favorite route adopted by most of the patent application filers, because of several advantages it provides for the people using this strategy. So, so how it works? So initially you file a patent application in your country of origin. For example, if you are filing a patent with Indian Patent Office, and within 12 months you can file a PCT application. So within 12 months you need to file a PCT application mentioning the receiving office and designating all the states, all the countries where you want to enter. So the same application will be published after 18 months. So after 18 months, it moves to the international phase. International phase means PCT will be the centralized organization which will process your application. For example, it will issue an international search report. It will also issue a report by the International examining and examination and publication. So that is called IPER. So that is one single international body which process your, all your application. So you will have a maximum time frame of 30 to 31 months to enter various jurisdiction of your choice. So if you compare this with the Paris Convention, there are several advantages. First of all, the main advantage is that Paris Convention gives you only 12 months of time, whereas PCT will give you a time of 30 to 31 months time to enter into various other jurisdiction by still retaining the priority date of your first file application. So the significance of, what is the significance of filing a PCT application? So this is the most tried and tested international filing system. So it is not a patent granting system. Many of us are confused with the way it works. So first of all, it is not a patent granting system. It is a facilitating system. It just facilitates to enforce your patent, implement your patent in various other jurisdictions by getting you a time of 31 months time. So each designated office makes its own decision on patent grant. As I said earlier, what is decided by the Japanese Patent Office will not influence the decision to grant or reject a patent in European Patent Office through this mode. So impetus for improving the international patent system is also in place because of this PCT. It's a great model for international cooperation for granting patents. There are 158 member states which are party to this PCT route. So now PCT has a wealth of scientific and technical information because of the humongous amount of patent application which has been filed with PCT. So as I said earlier, PCT presents several advantages. For example, it postpones the major costs associated with internationalizing a patent application. For example, through Paris route, if you want to enter an application which is filed in India to China, for translating the application into Chinese, you need to spend a lot of amount of translation. But whereas when you file a single PCT application, translation is being taken care of by the PCT. So hence you save a lot on translating your patent application, and the official fee for entering into various jurisdiction is also reduced by entering through PCT. And fee for filing the local patent agents in the US or in the Europe is saved. The cost associated with paying fees to this local agents is saved because of filing a single PCT application. So these are the statistics which I want to share with you all. So in 2024, there are approximately 2,73,900 PCT application filed, so which is 0.5 increase over 2023. And China topped PCT filing with 70,160 application, followed by United States, Japan, Korea, Germany, and India filed 4,552 application, and it took 9th position. So global patent application itself, faced an increase of 2.7%. Reaching approximately 3.6 million applications. So all this information has been taken from WIPO website. WIPO is nothing but World Intellectual Property Office. So that's it. My presentation is done. So I'll move on to quiz. I'm sure the presentation was informative. So yes, let's see how far you have understood. So my first question is, which of the following is generally patentable? Option A is a newly discovered natural protein. Option B is a purified and isolated form of a known natural protein with a novel industrial use. C, a mathematical formula. D, a naturally occurring gene sequence. I mean, can any of you answer? Or what do you think will be the answer? Option A, no. So you should see
The
the
newly discovered natural protein.
No, because it is just a discovery. You are just discovering, you are not contributing anything to the protein which is occurring naturally, right? You have just discovered. Can you file a patent for discovering oxygen? No. So the correct answer is option B, a purified and isolated form of a known natural protein with a novel industrial use. So because you have taken effort in order to purify and isolate a known natural protein, and you have also come up with a novel industrial use for the naturally occurring protein, right? So the correct option is option B. Question number 2, it's a true or false question. A method of treatment for a human disease, is it patentable in India?
No.
Any answers? Yes. So, method of treatment cannot be patented as per section 3I. Any method of treatment or diagnosis are not patentable under section 3I. So, I'll come to the third question. Which of the following invention is not patentable in India? A new drug formulation with improved stability, a computer program per se, a novel method to increase protein expression in bacteria, or a new class of synthetic enzyme. Any answers? So the following is not patentable. No. A new drug formulation with improved stability. That is a technical contribution. Improved stability is a technical contribution. So option A is patentable. A computer program per se. Section 3K. I have given an example also about the AI-based healthcare patents. Right. So option B, computer program per se. If there is a technical contribution to an existing problem, then that particular program is patentable. So there has to be a technical advancement. If there is no technical advancement, then a computer program per se is not patentable. It is a subject matter of copyright. One second. So I'll move on to the next slide. Can a diagnostic method carried out on the human body can be patented in India? So option A is B, no. C, only if it is novel. D, only if it is involved software. So what do you think the answer for this question will be? I've just discussed the answer.
Only if it is novel.
Huh?
C.
No, the option is diagnostic method carried out on a human body is not patentable. A method of treatment or diagnosis is not patentable under section 3I. So answer is option B. Moving on to the next question. A use for a known substance is patentable in India. Is it true or false? A new use of for a known substance. I think I have given an example for this particular concept also.
Yes, yes. Yes.
No, a new use for a known substance is not patentable in India as per section 3D. So I've given that aspirin example, right? So aspirin, a patent for aspirin already exists. So a new use for aspirin is not patentable unless you come up with an enhanced efficacy. So question number 6, which of the following may be considered patentable if it involves human intervention and technical advancement? Option A, naturally occurring DNA. Option B, isolated and modified DNA with a novel function. Option C, genetic sequence found in nature. Option D, basic scientific principle. Any guesses? Option answer would be option B, isolated and modified DNA with a novel function. So, here the DNA has been modified, right? So the process taken for modifying the DNA, and by modifying it, you have achieved a novel function. Hence, option B. So, question number 7, a novel microorganism developed using genetic engineering may be patentable if option A, it exists in nature, B, it is an abstract idea, C, it is capable of industrial application, D, it is used for academic research only.
C.
C. Yes, right. Good. Question number 8. Which section of the Indian Patents Act bars the patenting of invention contrary to public morality or which cause harm to life or environment? Section 3D, Section 3I, option C, Section 3B, option D, Section 3K. So the answer is option C, Section 3B. So we have seen the example of gambling device and device for theft, performing haste. All these things are contrary to public morality, which are barred from patenting as per Section 3B. Question number 9, a scientific theory is patentable if it's new. Is it true or false?
No.
True. Yes. False. Good job. So, which of the following invention related to biochemistry is most likely patentable? Option A, a method to teach enzyme kinetics, a novel vaccine composition against a known pathogen, the discovery of a plant with antibiotic properties, a mental process for memorizing amino acid codes.
D.
Yes, right. Good. So, question number 11, true or false? In India, software combined with hardware to perform a technical function can be patentable. True or false?
No.
Is true, because a software combined with hardware is patentable. As I said earlier, there is a technical advancement which is achieved because of the software used, hence it is patentable. So, question number 12, a new chemical compound showing inhibitory activity against an enzyme is discovered. Can it be patented? Option A, no, because it's a chemical. Option B, yes, if it is novel, inventive and industrially applicable. C, no, because it's related to biology. Option D, yes, even if it is already known. This is an easy question. Any answers?
C.
No, answer is B. Yes, if it is novel, inventive, and industrially applicable, it can be patented. We have seen the three golden rule of patentability, right? Novel, inventive, and industrially applicable. So the same applies here. So question number 13 is which of the following is not patentable under Indian law? A novel apparatus for protein purification. Option B, a method for treating cancer in humans. Option C, a novel biotech process to synthesize a compound. Option D, a pharmaceutical composition with unexpected efficacy.
B.
Yes, right. A method for treating cancer in humans. So moving on to 14th question, can a lab manual or protocol be patented? This is very, very easy. Option A. Yeah.
No.
Yes, no. So last question, invention relating to stem cells are fully patentable in India?
Yes.
No, it is not patentable. It is not patentable. It is not patentable as it falls under section 3B because it is against public morality. First of all, for ethical concerns, it is barred from patentability. And also under section 3J, any a plant or animal has a whole or in parts thereof, so cannot be patented. So it cannot be patented both under section 3J and 3B, and also section 3I if you are going to use the stem cell for as a method of treatment or diagnosis. So under 3 sections it is not patentable. So yes, so I come to the end of my session. Hope you enjoyed the session. If there is any questions, please shoot. I hope the session was informative. Any questions?
Yes, madam, it is informative.
Feedback? I think as researchers, you might be having a lot of questions whether to file a patent for your research or not. If you have any such questions, feel free to ask. This is the right platform.
Hi, ma'am. I have a question. I'm Irfan. I do have a lot of patents, so I'll be one of the presenter on the trade secrets on Friday.
Okay.
So I do have a lot of US, Canadian, and European patents.
Okay.
We did an international PCT in 2014,
Okay.
depending on the kind of business we have. I have received all the patents of Europe, US, and Canada. Indian patents still we have not received, madam.
Okay.
So, we've been following up with them, and, they take a long time to do all this. And, because of which, as an industry person, by the time I come with the patent, my business would have been gone. So that is one thing which I'm facing with Indian patent guys, which a lot of office actions. We have given details and other things. So we have still not come back to that, this one patent.
Yeah, but you still have the patent application which you had received after filing, right? So
Yeah, I do have.
you can use that information in order to submit it to your investors. I'm sure it will have importance because it is in prosecution stage, and you can also mention that the same has been granted in other jurisdiction. So I think that will help as of now. Having a patent filed is also, considered very gainful when it comes to, showing that to your investors.
Yeah, they are aware because Indian patent, because it is an international PCT.
Okay.
The Indian Patent Authority also are aware of this, that it's been granted. I applied in 2014. I got my fast track. We did a fast track application. I think people will also know that there are fast track applications if you go with WIPO out of the country. And I used to do a lot of work with the patent this one. And within 2018, I got my US patent. Yeah, it comes at a cost. No, it's not easy. Not everybody can afford it. Like you talked about maintaining it. So it is a huge fees of more than 5 lakhs for an US patent. So we are just working with them, and still we have not got any reply. They will take some time, because one more thing I just want to add on here as an industry person, about the Biodiversity Act also, that comes in place actually when you apply for a patent if it's in micro India.
Can
Thanks,
I
ma'am.
request Ms. Gayatri Devi to unmute herself, because I'm not able to hear clearly what Mr. Irfan is conveying.
Yeah, it's okay, ma'am. I think I'm done. But I wanted to give an input on the biodiversity and other things. Anyway, when I have a session on 18th, no, I'll give some small input on other things also, because I've already gone through all this international PCT. So I'll be sharing my inputs on the trade secrets and copyrights when I give a
Sure.
presentation.
Sure,
Thanks,
sure.
ma'am. Thank
Looking
you for
forward to hear more from you on this.
Thank you.
Thank you. Thank you. So, yes, next question. Ms. Vashini. Yes. Please ask. Swashini. I think Ms. Vashini had a question. Any more questions?
If you have any questions, please ask the questions, please.
Yeah, I think most of
no
them are
more
trying to
questions.
understand this, because this is as faculties, these are all something out of it involves a lot of law and other things. So I think people are trying to understand. This is what my input.
Sure. I have provided my email ID in case if you have further doubts after this session, feel free to contact me.
Okay, any more questions? If anybody has any doubts, we just can ask the questions now.
I think no more questions. Padma ma'am, you can conclude.
Yeah, shall I conclude?
Yes, yes.
Okay. I thank Ms. Sai Priya Subramaniam ma'am on behalf of MMK and SDM Mahila Mahavidyalaya for enlightening us on the topic national and international framework of patents. Thank you, ma'am. Actually, it was very informative, but we couldn't follow because it is a new topic for us. So I think it was very helpful for the researchers and all other people. Thank you for sharing your knowledge with us. Thank you, ma'am.
Welcome.
I thank all the participants also for joining with us. Thank you. We will meet tomorrow at 6:30 on next session by Sunitra ma'am. Thank you. Thank you, one and all.